Welcome back. Once again, we have Arise News analyst Emmanuel Ifeni in the studio with us to explore this critical decision on Executive Order 10. So thank you for coming in. And what do you make of the Supreme Court's decision?
Yeah, like I said earlier, the Supreme Court judgment was long in coming because we're all aware that the 36 attorneys generals of the 36 states of the Federation dragged the federal government to the Supreme Court over this Executive Order 10, which was issued on May 20, 2020 by President Buhari to tackle the issues of autonomy, financial autonomy for the state legislatures and the judiciaries. And perhaps clearly, the president has the powers to make executive orders, which he drew from the Constitution, but to the extent executive orders are not primary sources of law, they are at best subsidiary sources of law. And to the extent that such orders conflict with the Constitution, of course, they will be null and void. And this is what the Supreme Court, in a decision 6-1, 7 justices sitting over this case, just declared that the executive order, of which the president even set up a presidential implementation committee, that executive order is unconstitutional because it is a clear violation of Section 6 and Section 8.3 of the 1999 Constitution, which gives the responsibility of funding state high courts, Sharia courts of appeal, and the customary court of appeal, the responsibility of the federal government. Now, the state governors were also asking for, especially some states that have spent substantial money in building structures for this customary court of appeal and state high courts. But the Supreme Court also rejected that request, that there should be no refund, because these states were claiming almost 66 billion, which they have spent on capital projects for state high courts, Sharia courts of appeal, and customary courts of appeal. But the main issue here is that the Supreme Court has said these courts, state high courts, Sharia courts of appeal, and the customary court of appeal for all states, that is the responsibility of the federal government to fund them, not states. So clearly, it's in a violation of the Constitution. And once the Supreme Court has ruled, of course, that is the final story. But the issue of autonomy, financial autonomy for the judiciary and the legislature will certainly not just go away. Perhaps how to go about it will be something that both the National Assembly will look at in future when it comes to issue of amendment of the Constitution, because at the state level, it is very important that the legislature, and the assembly, the citizens should have their own financial autonomy in line with separation of powers by the 3 arms of government. So, for now, that is the ruling that has come from the Supreme Court.
So I was actually going to ask you, isn't this ruling a setback, on the clamor for judicial independence?
Well, it looks like a setback. But again, the principle of judicial autonomy and autonomy for the state legislature is in itself something that is sound any day, which the Constitution encourages, but perhaps is how the president has gone about this, because executive orders must be in line with the spirit of the Constitution, and where it conflicts with the spirit of the Constitution, of course, we have a case like this. This is not what happened in the case of the U.S., where the president also presidents usually issue executive orders to make law in a way. Remember the case of Harry Truman, who once issued executive order to seize all the steel mills because the steel mills wanted to go on strike. Of course, he was dragged to the Supreme Court, and the Supreme Court ruled that he had no such powers to seize steel mills across the United States of America. So this is a democracy in action, and our Constitution being interpreted rightly by the Supreme Court in this case.
So given all that you've said and given all that is happening right now, do you think the president was ill-advised?
Well, the fact is that the intention of the president was quite noble. Also, to him, is in giving effect to the implementation, execution of the Constitution. That was his intention. So it's not a setback as for him as a person, but the system will now go back and look at how to ensure that there is financial independence and financial autonomy for state legislatures and state judiciary. But certainly the way he has gone about it, well, the Supreme Court has said it is not in line with the Constitution.
And one justice, out of all of the justices, it was only one that gave endorsement. What does that say about her? I think it was Uwani Aba Aji. She was the only one that gave, only one justice that gave endorsement.
Well, not unusual for justices to disagree, but once you have majority, even if it is 4-3, yes, you take note of the minority judgment, but that is what it is, minority judgment. The law is that of the majority judgment. In this case, okay. 7-1, quite some distance, you would say.
It is.
But we take note,
yes.
And I'm sure lawyers, students of jurisprudence will review that of the minority judgment to see what the point is making. But the law now is that of the 6 justices in this case.
All right, then, Emmanuel Ifeni, many thanks for coming on, shedding more light on the Executive Order 10. Many thanks indeed.